Did you have a weapon on your person?
Yes, unfortunately.
All right. And you were carrying that weapon, and you understand that in carrying a weapon, even as authorized under CCW or CPL, that there are certain places you cannot carry that weapon.
I absolutely do, which is why it was a total accident. Like it wasn't, I've had that gun since 2018, never had a problem. And that was literally a slip of the mind after the car accident. So I did it. I just didn't.
Well, okay, but you understand, right?
Yes.
And you understand that one of those prohibited areas is a hospital.
Yes.
Honor Joy Gaines, Senior Assistant Public Defender, representing Miss Addison.
Mika Addison. He didn't catch it this time. Or did it on purpose?
You don't?
No, my name. It's Mika, not Micah.
Oh, so you went up and just what? I call 1,000 names a day, and you gotta pick on one. No, never mind. No, I'm done. I'm done. I do the best I can. Sit up here. I sit up here and I try to dispense justice, and you call me out on one. You and her. I know Gaines is involved in this someplace. Fine. What are we doing?
Your Honor, you should have a plea form for Miss Addison.
I do. Plea form indicates that she's going to plead guilty to the charge of possession of firearm on the restricted premises, a 90-day offense. Upon her successful plea to that charge, count one would be dismissed. And there's a sentence agreement between the people and defendant. She can be sentenced under the prosecutor deferred program, which is really what this would be. All right. That's the court's full understanding. Is that correct?
That's correct, Your Honor.
Now, what's your first name again?
Mika.
Can we have Mika sworn, please?
Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Mika Addison.
You knew that. Ma'am, is this court's understanding that you're going to be pleading guilty to the charge of possession of a firearm on restricted premises? That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. I think it also requires forfeiture of the device. I'm not sure.
Well, they already have Stella. I'm sorry, the gun. I call her Stella, but they took it at the time.
Stella?
Yeah, they took it at the time of the offense, and I just
Stella?
Yeah,
She named her.
That's my girl.
Stella.
She protects the house. Okay, I have two daughters.
Stella. Anyway, go ahead, buddy. It does. All right.
But they already have it. They took it at.
I know,
and
but
I just never filed for it back because I knew better. So they already have it.
knew better except to name her gun Stella. All right. Anyway. All right. So it does require mandatory forfeiture of the weapon or device. You understand that?
She's gone.
Yes, she's gone.
I warned her already.
I hear a Hall and Oates song in my head.
Understanding that, ma'am. Do you still wish to plead guilty
Yes.
to the charge of possession of a firearm in a restricted premises? How do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You had signed an advice of rights form, is that correct?
I did that right.
Yeah, that's the one.
Yes, I did.
Any questions regarding any of those rights?
No, ma'am. Or no, sir. Sorry. I was talking to, yeah, no, sir.
Mm-hmm. Okay, Micah.
Yeah.
No.
I knew it.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you? You're doing this voluntarily
Yes.
of your own free will
Yes.
because you believe that you are indeed guilty?
Yes,
November 14, 2025, at the location of 1500 East Medical Center Drive in the city of Ann Arbor, Washtenaw County, state of Michigan. Did you have a pistol concealed on or about your person?
well, it was January.
What did I say?
It took them until November to even say anything, and they picked me up at home. But yes, I was at the University Hospital in January after a car.
Did I say January 14th? I said February? No, I don't. Really don't.
Me either. I understand.
But, all right, let me do this again. January 14th, 2025, location of 1500 East Medical Center Drive, city of Ann Arbor, Washtenaw County, state of Michigan. Did you have a weapon on your person?
Yes, unfortunately.
All right. And you were carrying that weapon, and you understand that in carrying a weapon, even if authorized under CCW that, or CPL, that there are places, certain places you cannot carry that weapon.
I absolutely do, which is why it was a total accident. Like it wasn't, I've had that gun since 2018, never had a problem. And that was literally a slip of the mind after the car accident. So I did it. I just didn't.
Well, okay, but you understand, right?
Yes,
And you understand that one of those prohibited areas is a hospital.
yes.
All right. Ma'am, I do have to advise you, if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
I do also have to advise you before I take your plea, you understand I'm taking your plea, but you would be sentenced by Judge Garwood in the 15th District Court.
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 15th District Court. Sentencing will be
March 17th at 9 a.m.
March 17th, 2026, 9 a.m. before Judge Garwood. And in finishing this, bond is continued and Stella gone. No. All right, thank you.
All right.
All right. Thank you.
Thank you.
I think that's it for me. These people versus Lucretia Hunter.
And good morning, Your Honor. Joseph Paul appearing for and on behalf of Ms. Hunter, who is approaching. Ms. Hunter, when you arrive, could you state your name for the record, please?
Lucretia Hunter.
Hold it. Were you here? You're in this block too?
Yeah, Judge. I can stick around all day if you know.
Why are you threatening?
Your Honor, on this matter, we've very recently retained. We have received the police report, but we're awaiting further discovery of the adjourn date for PCC.
Probable cause conference, March. Hey, remind me, what did I set your other ones?
I believe
The 12th or 19th?
we have one on the 12th.
12th. March 12th, 2026, 9 a.m.
And Your
I
Honor,
don't know why I'm being so courteous today.
I appreciate it though,
No,
Judge.
but it's
You know,
really throwing me off. I feel that way.
well, continuing that, Your Honor, to ask Your
Now
Honor,
you're gonna mess it up.
I probably am. Your Honor, I'm
You
going
are.
to bring up just
You're gonna
one
mess it all up.
one part of bond today, Your Honor. That is that I know that is that Miss Hunter is currently wearing a tether. It's a GPS tether.
Mhm.
She's got a 16-year-old at home. She's a single mother. She's 37 years old with no prior record of any kind.
Free to put the tether on the child.
What's that?
Nothing.
You never want to offer that to
Yeah,
a parent of a
it's a
teenager,
teenage.
Judge.
Yeah.
But you know, it's interfering with a lot of parts of her life. She has not violated in any way since that thing was imposed. She has no interest in seeing the alleged victim of this case, and doesn't really have some pre-existing relationship with this person.
Response from the people.
Your Honor, we'd ask each other to remain. I do know something from the odds where there was an assault conviction. But
For-
the incident
An ag assault on,
By this, the defendant has a conviction from 2008 or 9. So it's older. The reason I would request that it stay is this appears to be an incident that also involved various former and current relationships and overlays with all that. So I think that keeping them apart, knowing, giving the victim peace of mind is important. Give them a chance to contact the victim.
Yeah, just-
Contact the victim regarding that.
On information and belief, an ag assault was thrown out in the aughts. So I don't know if
No,
that's challenging anyone,
that's fine,
but
it's 8, I was like 12 when that.
and so Your Honor, and these connections are alleged to be with the defendant's sister, not the defendant. So she really has no overlap unless you go through family and other things. She knows where the lines.
Who is this person
This is
in
a
relation
person.
to, the alleged victim is whom to this defendant?
So the alleged victim's baby's father was allegedly sleeping with the defendant's sister, which caused the alleged victim to go to the residence of the defendant's sister. And this incident
And she
arises,
happened to be there,
and,
and she's at her.
but we don't want to.
The defendant may have been at her sister's place, then this person comes there.
Yes, that's on information and belief, Your Honor. That's all correct. There's no allegation of seeking out.
Other than that,
That's it, Judge.
is there any other connection that this individual would have with this person?
None whatsoever.
And she's got a GPS teller, so it's not even it's not even one that has an exclusion on. It's just a GPS tracking where she's going.
I believe that's correct. There is a no-go to here.
Right, there's a no go-to, but I mean,
I don't want to speak out of turn, Your Honor. I do not.
no, I got you, and I realize you just got into this.
Some GPS tellers have what's called an exclusion
Judge, my notes from the arraignment show an exclusion. GPS teller with an exclusion.
Yeah. No.
I'm going to continue the defendant's bond, however, I'm going to remove the GPS teller. I don't, if circumstances such as that, I don't see a need for.
Thank you so much, Your Honor.
You'll, I'm sure, inform your client, don't give me reason to put it back on or incarcerate it, right?
Very clearly, Your Honor.
Huh?
Thanks again.
Yeah, well, yeah, so that there's an order to go over there.
Take care, Your Honor.
Thank you.
Thank you.
Court calls case People versus Edward Gross.
Morning, Your Honor. Raymond Cook, People. Assistant Public Defender Jay Bellinger on behalf of Mr. Gross, who approaches Your Honor. Can you please state your name for the record?
Edward Gross. How are you, sir? Hi. Are you a Chiefs fan?
And
I'm.
I wasn't born and raised.
Show 'em what you got.
What?
It depends on if you are.
I'm not.
I'm not either.
Show them what you have. Show them what you have on under that.
But I got this just in case.
Okay, all right. Well, okay, that'll work.
Your Honor, we are here for a plea today.
All right, I have a form that indicates he's going to plead to an added count 2 of retail fraud second, the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That is the court's full understanding of the agreement.
That's correct, Your Honor. That is our understanding as well, Your Honor. And is that your understanding, Mr.
Yes,
Sir?
Yes. Yes.
May I have him sworn?
Raise your right hand.
Other right hand.
Sorry, man.
He's a Chiefs fan.
Yeah.
Anyway, go ahead.
Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Edward Gross.
Sir, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right, you signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as other rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Not-
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
I am a Chiefs fan, but that doesn't count. No, Your Honor.
Has
No,
anybody threatened you or coerced you?
no, Your Honor.
You're doing this voluntarily
Yes.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Oh, yes, Your Honor. Sorry.
October 8th, 2025, at the location of 3825 Carpenter Road, in Pittsfield Township, Washington County, State of Michigan. What'd you do at the Meyer store that makes you think that you're guilty?
Your Honor, may I?
Yes, please.
You were at the Meyer store on that date and time?
Yes, sir.
And while inside the store, did you take or move sports trading cards and grocery items that belonged to the Meyer?
Yes.
And at the time you did that, you had not paid for the merchandise, is that correct? And when you took or moved the merchandise, did you intend to take it without paying for it?
Mm.
And you understood that the merchandise belonged to the store and not to you, correct?
Yes.
And the value of that merchandise was more than $200, but less than 1,000?
Yes.
And that store was open to the general public?
Yes.
Satisfied, Your Honor?
And you didn't have anybody's permission to take that property, did you, sir?
No, Your Honor.
Sir, I do have to advise you, if I accept your plea, between the time that I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that the court would not be bound by any sentence evaluation or recommendation, and you could not withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None, Your Honor.
And have I complied with the court?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation.
That's here.
Sentencing in this matter will be
March 11th at 9 a.m.
March 11th, 2026, 9 a.m. That's before me. Bond will continue. Thank you. Sir, on your way out, my probation department is on the left-hand side down the hallway. You need to stop in there before you leave the building.
Okay.
Understood?
Yes, Your Honor.
And Yep.
And then,
Court calls the case, People versus Robert Harris.
this is Public Defender Jay Bellinger on behalf of Mr. Harris, Your Honor, who should be in appearance via Zoom.
Harris? Nope.
Harris? Your Honor, I would request, we were in contact with Mr. Harris, Your Honor. I have had contact within the last few days with him. I'm surprised. I'm just as surprised as the court is, I assume, that he's not here today. So,
I'm not shocked.
oh,
No, I'm kidding. No.
so I mean, I would ask for an adjournment on this. We have had contact. He is still working towards a misdemeanor on this case, Your Honor.
Bench warrant will issue for defendant's failure. to
Come on.
Bond, 10,000. Cash surety. That warrant will issue immediately.
Immediately.
Yes.
What about like in 2 days from now?
No.
Give me 48 hours.
It's gonna issue as soon as that file gets down here and you keep talking, I'll get a clerk down here to enter it now.
Thank you.
You're welcome. Court calls the case, People versus Kenneth Herndon.
And is that on behalf of the people, Your Honor? And Maggie on behalf of Mr. Herndon, who's approaching.
Kenneth Herndon. Thank you, sir. Yes, sir.
We'd like to set this matter for exam and all discoveries complete as far as we're aware.
How she's been doing all day.
Mr. Brown taught me well.
Is that what he taught you? To do this?
Yes.
No, that's not what he would do. People, other witnesses available on the 3rd? Preliminary examination in person, March 3rd, 2026, 9 a.m. before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Was the court, that was a progress report? From.
Yes, I am. Do you have a
Yes, sir.
he has a medical marijuana card that, well, do you currently have do you have a new one?
No, I still have one it's,
And Your Honor, I think it says it expires.
Oh, it expires later this year.
yes, sir.
Okay. So,
There was a missample.
He, if I may, he got into a car accident that day and he called his probation officer right after that occurred and he tested on the next available day when it was open.
And I'm ordered to go today as well.
gotta state he was, yeah, he missed a sample, but it says he was in a car accident. You said you tested. I just don't have an update.
Yes, sir. I tested and I'm tested today as well.
Pardon?
I'm supposed to test today as well. And I tested after that day.
Oh,
Nope.
it's fine. He's
Thank
good.
you.
Thank you.
Mr. Allen.
Thank you,
What?
sir.
You wanted to take him. You did?
Getting ready. He was.
What? I know, he's getting ready. He's always, Alan is always ready. Uh-oh. You good? What, you want me to take, you want to go with Mr. Allen? All right, then go. He didn't quite know what to do. Court calls the case, People versus Dustin Hufford.
And back on behalf of Mr. Hubbard, who is opposing. Please state your name.
Dustin Hufford.
Thank you.
And at this time, we are waiving preliminary exam.
Sir, you're waiving your right to a preliminary examination? Yes?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them? Yes?
Yes, sir.
All right. And you understand you'll not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right?
There is an offer extended, that Mr. Hubbard can avail himself of the circuit court with the pleads account 2 and the dismissal of count 1.
Got it. Preliminary examination having been waived, defendants bound over to circuit court on both counts. Okay.
We acknowledge receipt of information, waive formal reading. My client will stand mute.
Where'd you go? You just. Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pre-trial in this matter will be set for
April 9th at 1:30 with Judge Slay.
April 9th, 2026, 1:30 before Judge Slay.
Thank you, Your Honor.
Thank you. Bound will continue. Court calls case, People versus Roderick Jacobs.
Assistant Public Defender Dave Bellinger on behalf of Mr. Jacobs, who is here, Your Honor, and approaching. For the record,
Roger Jacobs.
and Your Honor,
Yes, I see the reason.
thank you.
Probable cause conference will be adjourned then to February 26th,
Thank you.
2026, 9 a.m. Bond continued. Thank you, sir. Court calls case, People versus Jalen Johnson.
Welcome to people.
Assistant Public Defender. On behalf of Mr. Jalen Johnson, I believe he is on Zoom, Judge.
What makes you think that?
Oh,
No, he's here.
yeah. Oh.
But Mr. Johnson, you need to turn on your camera and unmute. Sir, state your name.
Jalen Johnson.
All right.
Judge, you're asking for an adjournment in this matter. Thank you.
I'm the way I know she takes a while, so you just go to rest in between. What?
We're asking for an adjournment in this matter, Your Honor. We are still doing some investigations.
Probable cause conference will be adjourned March 12th, 2026, 9 a.m. Bond continued.
Judge.
Thank you, Your Honor.
Thank you. Thank you, sir. Court calls the cases of the People versus Don Jones.
People,
Michael Gaddy, Assistant Public Defender, on behalf of Ms. Jones. Make your way to the podium, Judge.
Was she throwing stuff? Huh?
Handed her keys back.
She didn't hand anything. She threw them.
I sure did. I'm sorry, Your Honor.
She threw them at her. Oh, who's that?
She knows how to catch. That's my mom.
You threw keys at your mom?
I know she can catch.
No, you threw things at your mom.
Yes.
That's all we're getting out of this.
I told her to, Judge. We're having tryouts for the softball team this week.
Mr. Gaddy will do anything to protect his client. All right. She's waiving her right to prelim on both of these.
Yes, Your Honor, I've gone over her right to a preliminary exam with Ms. Jones. She wishes to waive the offer moving up is dismiss one on a plea to one and no habitual.
That's correct. One agenda, that rest.
That's correct.
All right. Ma'am, is that right? You want to waive your right to preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and committed.
I do, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
I do, Your Honor.
Your Honor, on
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count in both cases.
Your Honor, we'd waive reading of the complaint, stand mute, and acknowledge receipt of the information.
Defendant having waived from a reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 13th at 1:30 with Judge Mammud.
April 13th, 2026, 1:30 before Judge Mammud.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue only if you apologize to your mother for throwing things at her. Wow. 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 That's how people get locked up. Jeez. Thank you. You do the same. Wow. Sorry, not sorry. That's your mom. You don't understand how I feel about moms. Court calls the case, People versus Travis Canard.
Probably carry I can really, Your Honor, on behalf of Mr. Travis.
Canard.
Your Honor. Travis Canard.
I have before me a plea form that indicates that the defendant will be entering a no contest plea to the charge of aggravated assault.
Yes, Your Honor, that is
A
correct.
1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There is an agreement to a sentence under a prosecutor's deferred program.
Correct, Your Honor.
Thank you, Judge.
I have him sworn.
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, sir. Yes. State your name, please. Travis Canard.
Sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated assault. That is a misdemeanor, punishable by up to 1 year incarceration or $1,000 fine plus court cost. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And sir, to that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Say anything? Yes, Your Honor.
Any questions regarding those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that court.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
All right. Court has been handed and has reviewed Ypsilanti Police Department report. Ypsilanti Police Department report for their case number 25-15700. Any objection to the court having reviewed that?
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis on which the court could determine the defendant's guilt of this offense. Sir, I would have to apprise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor.
And have I complied with the court rule?
Defense is satisfied, Judge.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
March 4th at 10 a.m.
March 4th, 2026. I'm sorry. Time,
10 a.m.
10 a.m. before Judge Barr. Bond will continue. Thank you. And counsel, can you, and to all of the PDs, but I should have said this earlier, you make sure that all of your clients have the contact information for the public defender. There's been a rash of cases in which they have not contacted, I should say probation department. They have not contacted the probation departments, and I don't want to have to take any further more drastic action, but I will. But I'm hoping you can be cooperative in that process. Ms. Second, can you?
I absolutely.
I think all of the rest can.
Your wish is my command, Judge. Your command is my.
That is so, you are so. That has never been your position in this court. Thank you, though. Wow. Court calls the case People versus Christopher Lamrose.
An assistant public defender, Jay Bellinger, on behalf of Mr. Lambrose, who approaches. Can you state your name for the record?
Christopher Lamrose. Thank you, sir. I have before me the plea form. Indicates that he's going to be pleading guilty to the charge of OWI second. That's the 1-year offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of it.
That's our correct understanding as well, Your Honor. You're correct.
I haven't sworn.
Right. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, but so be God?
Yes, sir.
State your name, please.
Christopher Lamrose. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, $1,000 and up to a $1,000 fine plus court costs. The court could order community service or any rehabilitative services the court deems necessary. The court could order your vehicle immobilized, could order your vehicle forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that? Yes, sir. All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Understood. Still wish to plead guilty? And to that charge, how do you plead? Guilty. And you understand that by pleading guilty, you'll not have a trial of any kind? Yes, sir. You signed an advice of rights form, is that correct? Yes, sir. Any question regarding any of those rights? No, sir. Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form? Yes, sir. You understand you're giving up your right to appeal of right? Yes, sir. Are you on probation or parole? No, sir. Has anybody promised you anything other than what's been stated here today on the record to get you to plead? No, sir. Has anybody threatened you or coerced you? No, sir. You're doing this voluntarily? Yes, sir. Of your own free will? Yes, sir. And because you believe that you're guilty of this offense? Yes, sir. On July 16, 2025, at the location of Holmes Road near North Pasadena Street, Ypsilanti Township, Washtenaw County, State of Michigan. Were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes, sir.
What was that?
Okay.
And did you know that's what you were ingesting?
Yes, sir.
Were you stopped by the police or was there an accident?
Police stopped me.
Why'd they stop you, sir?
Erratic.
Pardon?
I was driving erratically.
All right. You're not disputing the right of the police to stop you in this instance?
No,
are you?
sir. No, sir.
Were you ultimately arrested?
I was taken to the hospital.
Cuffs?
Yes.
Then it's probably an
Yes,
arrest.
sir.
Yeah, okay. So, and then you were taken to the hospital and there was a blood draw?
Yes, sir.
All right. And did the results of that blood draw show the presence of cocaine and or its derivative?
Yes, sir.
You have any reason to dispute those blood test results?
No, sir.
And sir, had you previously been convicted of operating while impaired on or about September 23rd, 2023 in Ferndale, and or operating with the presence of a controlled substance on or about June 16th, 2020 in the city of Ann Arbor?
Yes.
Sir, I do have to advise you that if I accept your plea in this case, and you commit misconduct between the time of my acceptance of your plea and the time of sentencing, that the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No.
None, Your Honor.
And have I complied with the court?
Yes.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Pre-sentence investigation and screening and assessment is ordered at 14B. Sentencing in this matter will be
March 26th at 10 a.m.
March 26, 2026, 10 a.m. before Judge Washington. Bond will continue.
Thank you very much.
Court calls case People versus Tavion Lewis.
Your Honor, Raymond Cooper.
I can really, Your Honor, on behalf of Tavion Lewis, the record.
Thank you.
Your Honor, we respectfully request that this matter be set for preliminary examination.
Your discovery is complete.
To our knowledge, Judge, yes.
Other witnesses available the third. Preliminary examination will be set March 3rd, 2026, in person, 9 a.m. before Judge Perry.
Okay, wonderful. Thank you, Judge.
Bond will continue.
Okay.
Wishes her command, really? Court calls the case People versus Jimmy Ray Lips.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Lips, who approaches. Can you state your name for the record?
Jimmy Ray Lips. Thank you. He's waving.
He is, Your Honor. There has been an agreement to no MDOC on this matter contingent upon a waiver.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over circuit court on a single count.
Your Honor, we acknowledge receipt of information, wait form of reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter not guilty plea. Pretrial will be set for.
April 21st at 1:30.
Excuse me, let me just cross that out. What?
April 21st at 1:30.
April 21st, 2026, 1:30 for Judge County. Bond will continue. Thank you. Court calls the case of the People versus Khalid Mammud.
Assistant Public Defender Jay Bellinger, on behalf of Mr. Mammud, Khalid Mammud.
Thank you.
And Your Honor, we are just seeking an adjournment. We are awaiting potential discovery on this matter.
Potential discovery?
Potentially it exists, potentially it doesn't.
There are times you just want to shake him.
My mother did that when I was a baby.
So this is video outside of like police video and other.
It is
It's a
potential.
third-party- Okay.
It's potential
Made-
video from
I get
inside the jail, Your Honor.
Oh.
So it may not exist at this point.
The incident date was back in the fall, and it doesn't appear.
Got it.
Pittsfield case doesn't appear, at the time it occurred, that video was obtained at Pittsfield, so I tasked
So-
the OIC to see it. So
Gotcha. All right. Probable cause conference will be adjourned March 12th, 2026, 9 a.m. Bond continued.
And Your Honor, I'm sorry to bring this to the court's attention. My understanding, and I wanted to see if I might be able to get a sooner date because my understanding is that he's already set for a preliminary examination on March 10th on his other matter. And I wanted to,
On March 10th?
that is my understanding.
Okay.
And so I wanted to see about getting a sooner date.
So that if this has to go
Yep.
forth, it can, is it,
that's, I expect, I was emailing with the OIC yesterday, probably a quick answer, yes or no, and if it exists, we get them quick, so that's fine. If we want to go to the fifth on Mr.
That way we'll know. Okay.
okay, so follow along. We're gonna know by next week, right?
That's fine, yeah.
So just to keep everything, I see what you're trying to do, Mr. Bellinger. Most of the stuff you do, I don't understand, but this one I might. So February 26th. So adjourn this to next week, 2026 at 9. That way, if it's not there and you want to set for an exam, it would go to its natural date on the 10th.
Thank you very much.
All right. Done.
Okay, that's okay.
Court calls case, People versus Trayvon Marshall.
For the judge, court shall feast to assistant public defender to turn on behalf of Mr. Marshall, who should be approaching. When you arrive, please state your name for the record.
Trayvon Marshall.
Thank you, Judge. I've spoken to Mr. Marshall. My understanding is he would like this matter set for preliminary examination. I believe all discovery is complete.
People have their witnesses available the 3rd. Preliminary examination in person will be set March 3rd, 2026, 9 a.m. before Judge
Judge Rush
Fresh Hour. Bond will continue.
Thank you, Judge.
Thank you.
March 3rd.
Court calls the case of the People versus Keith Moore.
Good afternoon, Your Honor. Raymond Cook to the people.
Michael Gandy, Assistant Public Defender, or Your Honor. Your Honor, may we approach briefly?
Mr. Marshall steps forward with his public defender. Discovery is complete. Witnesses are ready. He requests a preliminary examination, and the judge sets it. March 3rd, 2026, 9 a.m. in person. Bond will continue. No drama, no argument, just the next legal step moving forward. Then another case is called. New names, new charges, same serious process. In felony court, this is where things start getting real. The preliminary exam decides whether the case moves toward trial or falls apart. So here's the question. Should every serious charge be tested in a full preliminary hearing before trial, like if due process matters? Share if the system should always be challenged in court.